September last year, I would have wished that the former president, didn't act upon it at all and would have left it in the capable hands of the incoming president. But that did not happen. That was not to be. And I also did indicate that if I were the incoming president, I'll also, leave it to the outgoing president to do it so that, none of them will be blamed, for whatever will arise from that petition. However, that was not done. The former president took a step, and in fact, it's a decisive step. If you will recall, I granted an interview on this same platform,
yes,
and I pointed out that the processes have been spelled out clearly in the Constitution, and I refer to Article 146, Clause 6. I'll refer to it again, and for goodness sake, just permit me to read it. Article 146, 6, and I quote, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices for the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, unquote. This is where every problem that has arisen in connection with Professor Kwekua's petition, is sourced or must be sourced. Where the petition is for the removal of the Chief Justice, the President shall act in consultation with the Council of State. Did the former President act in consultation with the Council of State? If yes, was a committee consisting of 2 justices of the Supreme Court set up? If yes, was one of them made chairman by the former president? If yes, were 3 other persons who are not members of the Council of State included? If so, we go to the next step. Those 3 people should not be members of Parliament nor lawyers. Did the former president follow that? If he did, there's nothing wrong, But I stand by what I observed of the examination of that petition or determination of that petition. I said that quite predictably, the former president might not have acted in accordance with due process, and therefore the incoming president will have a petition on his hands. And that is what is playing out now. Let us go back to Kwekua's petition and find out. Because I say so because if the former president acted in accordance with the provisions of the Constitution, whatever was the outcome is binding on the current Council of State. And therefore, the current Council of State will have to advise the president that it's a no-go area. It's not, a return match.
Okay, it would have been a double jeopardy, right?
Decisively in accordance with the Constitution. However, if the president did not do that, nothing prevents the current president from reopening the matter. I am all for that because the moment we were informed that the former president had made a final determination, of that petition, I granted you an interview and said it was going to generate another ugly problem, and that is what we are having now. So, in order to end this matter, let us just go back. We don't need, 1 or even 2 or 3. We don't need, any of them. What we need is a revisitation of the previous petition If it was not dealt with in accordance with the Constitution, then it wasn't dealt with at all, because whatever was done might have been a nullity.
Okay.
So that petition is still pending. Now, the Council of State is a creature of this Constitution, and therefore it is not a creature of any of the successive presidents since 1992. It's a creature of the Constitution, and if the Constitution speaks, then in accordance with Article 1, Clause 2 of the Constitution, is the supreme law, and it has spoken. And that pronouncement, finito. We are done with it. No one, is above the law. So the current president cannot question, a decision that was properly arrived at in accordance with the Constitution by its predecessor. He can't. If we allow him to do that, then, we may as well, throw away the Constitution and allow our president to come and, draw up new constitutional framework to govern the nation. But that is not what we ask for ourselves. Let us go back to the preamble of the Constitution. It said, we the people of Ghana, and not we the president or speakers, of Ghana. We the people. And we are talking, and we want, constitutional governance. So let us respect that, governance framework. You see, so that's it. Now this morning I've heard, people say, we don't know them. We don't know the petitioners. Where is it in the Constitution that is written that, the president, must make public, or make a public disclosure of the identity of the petitioner or petitioners? No. So the president is not constitutionally obliged to disclose the identity of a petitioner. Even for, the sake of security, it is unwise to do that. So as far as I'm concerned, I find nothing wrong with the president not disclosing the name and, full contact details, of the three petitioners. I don't think. But another problem Article 146 has created is that it says that one of the two justices of the Supreme Court, shall be a chairman. So it means that it didn't specify that those two to be, the first two most senior justices. Says justices. So we can even go to the bottom. Culturally, it is unwise for somebody, for a subordinate to investigate a superior. It is unwise. And therefore, by sheer constitutional common sense, it is the first two most senior justices of the Supreme Court. And the most senior of them should. And that is why the Constitution says, shall. So the most senior justice shall, be appointed or shall perform, the role, the chairmanship. So shall be the chairman. And then the next most senior, the member. Then it also, proceeds to say that the president, in consultation with the Council of State, in setting up a committee, shall also appoint three other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. So it gives room for the president, to appoint lay persons. That's my understanding. I mean, if you are a member of the Council of State, you are not a lay, member of the Council of State. You are a member. If you are, a non-MP, you are a lay MP. So if you are not a lawyer, you are a lay person. That's what the Constitution says. So for once, let us go by the dictates of common sense in construing Article 146. Don't let us bring a junior Supreme Court judge to oversee the removal of a superior. If when we do that, we are creating problems. So if for let's assume that Justice Eti is made to chair and the petition fails, do we realize the enormity of the problem the Constitution would have created for Justice Kwame Atiyeh. So let us go by the dictates of common sense
and go for the senior most
the most senior chair, followed by the next most senior. So the first two most senior justices of the Supreme Court should be appointed. The president has no choice than to appoint, the first two. That will make common sense and accord, with the sense and pride of the Constitution. Any other interpretation, is going to be a brutal movement. You will traverse and traverse and traverse and then come back, to the same thing. Also, that sort of thing is not, working out well for us. The next point is, let us find out, did former President Nana Addo Dankwa Akufo-Addo, in writing to dismiss Professor Adrae's petition seeking the removal of the sitting Chief Justice, did the former president act in accordance with the dictates of the Constitution? Did he follow, the framework outlined in Article 146.6? Did he consult the Council of State? Do they have minutes? Because the Council of State is a body created by the Constitution. It is a legal person. When it meets, it must, meet in accordance with the law and practice of meetings. Did they hold any meeting? When they held a meeting, who chaired? Did they have a quorum in, recognizing the chair? If they had a quorum, fine. If they did not have a quorum, then whatever they did will be devoid of legality, and as such will be null and void. Next, when the former president met or consulted the Council of State and they met, did they set up a committee which the Constitution requires or mandates or demands? Was it done? If the committee was set up, did it have, two Supreme Court justices? Did it have three other persons, who were neither members of the Council of State, nor members of Parliament, nor lawyers? If all those things were, did not exist, then their non-existence will rubbish whatever determination the former president did. If, on the other hand, the former president respected the Constitution, went about, the removal of Justice Tokonu the way the Constitution contemplated or adumbrated, then, nobody can, blame or question the determination that the former president made. But personally, I don't think that the Constitution was respected in its observance. I think it wasn't honored at all. I believe that determination was made so motu by the former president. And if so, nothing stopped President John Mahama to reopen or reactivate the file and bring it, into life for the Constitution, for observance of the constitutional processes. That will bring an end, to this matter. It is a needless constitutional issue that has arisen. Let us go about it, and I'm addressing the Council of State. Let the reconstituted Council of State go about this matter in the best interest of the nation, devoid of the fact that they have been appointed by current President John Mahama. I respect the composition. I respect the members, and I'm proud that the membership includes a former speaker, the number 2 or 3 in line, and then includes a former Chief Justice, the number 3 or 4 in line. So it is a body very distinguished, very capable. Let us allow them. Let us allow them. Don't let the president attempt to interfere, to dictate how, their mind should go or where their mind should go. Please, let us find out first whether former President Nana Addo acted in the best interest of the nation in accordance with the Constitution.
To the Constitution.
If he didn't, let's go about it that way.
Yeah, as you asked for, some evidence with regard to whether the former president followed due process as stated in the Constitution, in another aspect of your submission as well, you say that you feel that the president took this action suo motu. Am I correct?
Sure. That's what I'm saying. That's my impression, because I'm saying so having regard to some of the abuses and procedural lapses in the appointment of people the former president made. I'm questioning it because the former president not only bastardized the judiciary, but he also infected it with things that shouldn't have found their way into our constitutional dispensation. I stand to be corrected, but I don't think that in determining Tokonu's petition for the removal of Tokonu, the former president, acted in accordance with the Constitution. I don't believe it.
But the president, the former president,
the minutes to be produced.
Okay.
All of us. In the public domain, they could produce it for all of us to see.
But the former president was a lawyer. He knows the law. Why would he abuse it?
That's a regret. That is a regret, my sister. A former president, not only a lawyer, but as far as I'm concerned, one of very few best lawyers the nation, has produced. My sister, go into the Ghana Law Report. Go into the Supreme Court of Ghana Law Report. You can count 100 lawyers. Their production will not amount to, Nana Addo's production, including yours truly. Nana Addo is a very capable lawyer, very erudite. I mean, you would love to, see and listen to Nana Addo on his feet. But when he became president, power corrupts. Absolute power corrupts absolutely. Nana Addo became a tyrant. Something like a kakai. His ministers feared him. Everybody feared Nana Addo. So people, looked on while Nana Addo, did what he liked, what pleased him, to the extent that his spouse, the first lady, could even publicly be seen to be attacking an MP. That was the state Ghana, got to. And it is against this backdrop that I'm saying, I'm submitting, that as far as, I do know, it seems to me, and I stand to be corrected, but let the evidence be produced that the petition for the removal of the Chief Justice might not have been gone about, in accordance with the tenets.
And you believe that if that had been done, the current president would not have the need to start this process all over again?
Correct, because whatever pronouncement the former President Akufo-Addo might have made will be binding, upon the current president.
Yes.
Again, in accordance with Article 129, Clause 3 of our own Constitution. So here, I'm substituting, the president for the Supreme Court. So where the president makes a determination, it shall be on questions of law. It shall be binding on, his successor.
And in the instance where, for instance, in the instance where if the former president had gone through the process and eventually the Chief Justice was not removed. And a decision was taken. I mean, she was not removed. And this new administration comes in, and another petition is submitted. Could they state different grounds, or the grounds can only be what is stated in the Constitution, which talks about clear misconduct, among others? Can anything of that nature happen? Or once the grounds have been stated in the Constitution, that's the only grounds under which people can come to. Therefore, if you bring another petition after one has been declared already, it would render the others moot.
Yeah, on grounds of the distinctive public policy framework of Ghana, there must be an end to litigation. And therefore, if the Constitution has spelled out, the criteria, and the criteria was followed to the letter, no fresh petitions may be entertained. In law, we have what we call res judicata. The matter has been dealt with decisively before, and therefore, on grounds of res judicata, fresh petitions will be thrown out. That is the more reason why, when we are, we approach such constitutional matters, we need to be careful, when we are treading. We need to tread warily, the constitutional pathway. If you say that somebody should be removed on grounds of incompetence, what is competence? Who defines the competence? Is it, the person, the petitioner, or the Constitution? If the Constitution says, stated misconduct, and there have been previous decisions, explaining what the expression stated misconduct means, the committee is bound to follow that premise and act in accordance with the decisions of the previously decided petitions. That is one. Number two, it is not, and the Supreme Court made this this point quite clearly in the case against George Aqua, that it is not every little thing, that is extending to the way a manner a Chief Justice eats, the way a manner a Chief Justice talks, the clothing or apparel of the Chief Justice, and then you find it and bring it to the Supreme Court. In the Aqua case, they spelled out that it must raise a prima facie case. And if it doesn't raise a prima facie case, it is frivolous and must be thrown out. We are building a constitutional jurisprudence as far as the removal of the Chief Justice is concerned. So this is part of the developmental processes that we are going to go through as a nation.
Okay.
And once we are going through this, it becomes a faith in our constitutional, forward march towards, the desired Ghana Republic, that everybody will act in accordance with the concept of the rule of law, with the concept of due process, with the concept of respect for the Constitution, with the concept of respect for an obedience, for what our president, our vice president, our speakers, our chief justices, our attorney generals, constitutional bodies such as the Council of State, such as SHAD, whatever they do shall be respected. And therefore, it stands to reason that whatever we do in accordance with the four corners of what is written in the Constitution.
So,
and not on the BS of a president.
In your view, the former president did the Chief Justice a great disservice by dismissing the petition in that manner.
Not only by dismissing, the petition is not bad, but, in the first place, by getting her appointed.
By getting her appointed?
That's where the whole problem starts from.
What was the problem? What was the problem with her being appointed Chief Justice?
If you look, the problem was that if you look at Article 144 on the appointment, of the Chief Justice, 144.1, the Chief Justice shall be appointed by the President, acting in consultation with the Council of State and with the approval of Parliament. Let us go into history again and find out, the way and manner in which the President could possibly have acted, in consultation with the Council of State. Here was a president, who carried out his functions with careless abandon, largely with impunity, disrespecting everybody. And sometimes people meet me and ask me, do you have a personal problem with the president? I said, no. We were friends. We are still friends. But I am a senior citizen. When things are going wrong, and I cannot speak my mind freely, voluntarily, and in accordance with my own conscience, then what is my usefulness as a senior citizen of the nation? If others will not speak out, I don't want to be counted among the others. I want to leave a legacy that, when presidents come and they are misbehaving, I can call them to order. If every other Ghanaian will do that, my sister, will build a nation that will be the everybody's pride. That will be the engine of the so-called developed nation. That is where I want us to reach. That is how my mind is working towards. Let us do things for the betterment of Mother Ghana. We have no other Ghana. We have no other country. Ahaya, we were born here, we will die here, we will be buried here. Let's make Ghana a fine place to be born into and to be buried.
No,
when we answer our, its last call.
Okay, so on your argument that the problem was from the get-go with the appointment of the current CJ, and you reference Article 144, which is in relation to appointment of justices of the Superior Court and the chairman and other members of the regional tribunals. And it says here that the Chief Justice shall be appointed by the President, acting in consultation with the Council of State with the approval of Parliament. And for the other Supreme Court justice, on and on. So this one is just in relation to the Chief Justice, the first sentence. Is it your belief that that process or was not followed? Is that what you're saying?
Yeah, that's my argument. I have always stood, by the belief that Article 144, Clause 6, has the most say in the appointment of a Chief Justice. Article 144, Clause 6, provides that where the office of Chief Justice is vacant, or where the Chief Justice is for any reason unable to perform the functions of his office, then A, until a person has been appointed to and has assumed the functions of that office, or B, until the person holding that office has resumed the functions of that office, as the case may be, those functions shall be performed by the most senior of the justices of the Supreme Court.
Okay.
By the most senior. So whoever has the function to discharge relating to the appointment of the Chief Justice must abide by this. Go about it, under the constitutional wisdom. And the wisdom of the Constitution is that the most senior justice of the Supreme Court shall act until. Now, if the person is acting and the person is the most senior, why do you think that the premise of the Constitution chose to settle on the most senior justice? Because they believe that the most senior justice will fill the vacancy. But now, when you are filling the vacancy and you go and take number 7 and bypass the first 6, what have you done? Haven't you created a problem for the person himself or herself and for the nation? And that's the problem we're having on our hands. It has become an albatross. And if you don't take it, we continue to wear it as a talisman, which will not serve anybody any good.
And you see, others would argue that even though Article 144 Clause 6, which you reference copiously, talks about the one acting to be the senior most, others will say, okay, there's a loophole there. It doesn't also expressly say that the senior most should be the one appointed. It says while we are waiting for the appointment, the most senior should be the one to act. but it's not expressed that the most senior should be the one appointed. So others will say there's a leeway for whoever makes the appointment to choose whoever he believes is competent or believes should be the one to occupy that office.
I have a very short answer. There's a leeway in everything, even the way we eat. If you don't eat properly, you can have problems with it, isn't it?
Exactly.
If you don't eat properly, the way we swallow. So there's a way that we swallow food, isn't it? So if the Constitution says the most, senior, until, yes, that could be one argument. But if you are working in the best interest, of the nation, which becomes paramount, you just settle on the most senior. That way, nobody will raise any question unless the most senior person is suffering from some infirmity of mind or some physical incapacitation, or the person has, in the language of consistency, dissolable offenses. We can bring in some of these things, like the Chief Justice, as everybody knows the Chief Justice to be a drunkard. That, for instance, the person being the most senior may be bypassed, or the person is known to be a thief. The person is known to be a very corrupt judge. People are talking about the person. Those things. And then, we begin to question the criteria. But when you settle on just, a parameter, you take a criterion that because the Constitution, leaves a leeway, therefore, you are politically suave, and therefore, you settle on a political appointee, then you are not acting in the best interest, of the nation. It means that you are putting a spin on the constitutional provision. And I'm, suggesting that we shouldn't put any spin on any constitutional provision. If that were, so, like Chief Justice talk on no date in the declaration of the vacancy relating to the forces by the Right Honorable
Speaker of Parliament, Alban Bagbin.
Yeah, that, Article 97, raises a question of interpretation, so that even if there's no, issue of interpretation, you raise one for yourself and decide. When you do that, you bring, problems. And Tokonu has brought all these ugly noises, about her, by herself. And you'll be Nekumanki. She has stabbed herself, wrongly in the foot.
You believe her own conduct.
By her behavior on the bench, when they were determining when she composed, and I'll say she rushed to compose, a 5-member panel to hear, that. So for me, that's, with the greatest respect to Shakespeare, the most unkindest cat of all. The way and manner, she composed a Supreme Court to sit on a Friday in the afternoon, when the filing processes are not being done. I mean, if I had my way, she should be something, but not, to take a remover. That, I mean, she wasn't politically, mature enough, to hold the view that she did in, immediately, seeing or upon seeing after your marking, right to the Supreme Court to entertain, that deceptive process. You see, but that has been, an issue that has been, examined, and if it was, a sin, she can be forgiven. But we have a much more, problematic, issue relating to Kwekwa Drive's petition. I'm saying that petition was not properly gone into. So whatever determination was made was devoid of legality. And on that note, it must be roundly condemned and rejected as amounting to a nullity. And let, the Constitution speak, let President Mahama act in accordance with the Constitution to go into Kwekwa's entity and dismiss the first ones that have come. He shouldn't have referred them to the newly constituted Council of State when we have, one already, the constitutional and presidential back.
What if, for instance, Professor Kwekwa Azar has repetitioned the president? What if we don't know who we do not know who these three are? But what if he is part of the three?
But my sister, why should Kwekwa Azar repetition when the earlier petition has not been dealt with finality? Why?
Well, it's because the presidency at the time before they left office, they came out with a statement to indicate that they had dismissed it, and you have gone on to explain that you believe that due process was not followed, rendering what they did invalid and maintaining that then that petition still stands.
We should not be inundating the president with frivolous petitions every now and then. One petition is enough. If that petition has been carefully, properly, examined and dealt with finality, my sister, that should be the end.
Okay.
Unless a newer or newest petition assembles facts.
Okay.
That sits happily within the Constitution, then, there's a first ground, to entertain such a petition.
So,
but if the previous one was not, dealt with in accordance with due process, it is a nullity.
Okay.
And if it is a nullity, it is as if it was not dealt with.
It was never dealt with.
All.
Okay. Now, but does the president really have an option when a petition or petitions are submitted to him for the removal of the Chief Justice or any other head of some of these key institutions like SHRAJ, EC, among others, NCC as well? Does he have an option? Some say that he's just a mere conveyor belt. Does he have discretion as to whether he is forwarding this for consultation or otherwise?
That is why the Constitution, has provided a guideline and framework that in such matters, the first port of call shall be a consultation with the Council of State. And the Council of the members there are our wise men and women. They are imbued with wisdom. And that is how come the Constitution says that whenever the president, has a problem, the president shall consult them. So the Council of State is like an upper chamber, to Parliament, and therefore, the Constitution says that when any such petition rears its ugly head, the first person or the first entity to contact is the Council of State, because the Constitution believes that the Council of State will give wise counsel.
All right. So you've mentioned what your expectations would be. You say that you would wish that if anything at all, she should be sanctioned and not removed. And you also admit that you also argue that she brought many of these things onto herself. What are your thoughts? Some say that ever since there was a change in government, her visibility has been quite low. Is that an observation you have also made, or people are just, coming to conclusions on their own?
No, I don't think that people are coming or have come to conclusions, on their own. I think that the political terrain as it stands now has revealed one thing, which is very troubling. And it is that, every new government, has, a mandate to remove, incumbents to replace them with their own choices. It is a very worrying trend. It has divided the nation into two, into an NDC section and an NPP section. Very soon we'll have a CPP section, a Kwame Bediako section, Ancestry section, Akotiako section, Italy section. that will not augur well, for the nation. Let the president, act in accordance with the Constitution. I like one phrase. Each president, in their speeches, on the day they are inaugurated, will say that, I am, a father of the nation, so I am father for all. And then the moment they are sworn in, when they put their, presidential buttocks onto the presidential seat, it becomes something else. Then they forget about that lovely, constitutional phrase that I'm father, the nation. It is very, 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 very worrying. My appeal, to President Mahama and, successive presidents is that Ghana is one nation with a common destiny. All of us cannot become presidents. All of us are not presidential material. All of us wouldn't have the temperament, to run the presidential race. So whoever, sacrifices himself or herself, to become the president, is president, for all of us. So this trend of weighing Kayen, is not, one of us. It doesn't belong, to our philosophy. It doesn't, should, be relegated, to the background. What they should do is, if the person is fit for purpose, let that person continue to, or remain in office. However, having said so, my sister, we have a problem in this country.
Which
if
is?
President Mahama were to retain Godfrey Dami as Attorney General, you and I, would know what will happen. This is another, canker that must be eliminated altogether. Our loyalty must be to the Constitution and not to the human being. If our loyalty is to the Constitution, it doesn't matter, which political color or party color one wears. If ancestry is, fit for purpose and can function effectively and efficiently as, let's say, head of department somewhere, appoint him. I don't have, to be a member of the MPP and to wait for 4 years before, I'll be considered suitable, for appointment or something.
Right.
If I'm good to do something, let us appoint the person, devoid of, the political, leaning of whoever. I'm begging the president, this removal has become, too much. Too many. We are removing everybody. We will even remove the class 1 teachers, in due course. We are going to remove, every teacher and put our own people there. But
what do you
there
say?
are sensitive offices that the people should not remain. For instance, the IGP is a security matter. I am all for the removal. So the Constitution should spell out 4 years. So the Constitution, should be revisited. What they are doing about committee, I don't think we should, as a nation, hold a referendum and decide again that there are certain constitutional positions that must fall in line with the end of tenure of any political power, party in power.
Okay.
So if I appoint, I an MPP president appoint my IGP, I should go away with my IGP. Then the incoming president, that one, the Army commander, the Navy commander, the Air Force commander, the Bank of Ghana governor. There are certain, that we shouldn't leave the people there. That one, I agree. If Mahama will remove all of them, but we should not tinker with the judiciary.
So
That is the last bastion of our liberty. We should leave the judiciary alone.
Okay, now quick one. There are those who have said that some of the removals of the key or sensitive institutions, that no-go area belief that many held was violated when the then president succeeded in the removal of the EC chairperson. What do you say to those?
That was wrong. That was wrong. I question it. I mean, and they use her own classmates, to write a petition. So we'll be suggesting that current President Mahama will be right in removing the current EC chair. Is it going to do us any good? Why must we do so?
We must pull the brakes at a certain point, right?
The EC chair, the members of the EC, must be above reproach, above board. When they are appointed, let us believe, have faith in them that they will discharge their constitutional functions. If we give the impression that members and the chair of the EC are political appointees, then none of them. It means every 4 years we have to reconstitute the
commission.
Electoral Commission, and that is not good for us.
Thank you so much for making time to speak to us. We're grateful for your time, sir.
Thank you.
You had to speak to Ansa Asare. He's a former director of the Ghana School of Law, and he was sharing insights with regard to the latest development in connection with the petitions to remove the Chief Justice Gertrude Araba Isaba Saki Tokonu. It's still the morning, Sahil Star 103.5 FM. We have more perspectives to pick on this one.
And we've been joined on the phone lines by the former member of parliament for Tamale Central, and he's also a legal brain, Alhaji Inusa Fusheni. Alhaji, welcome to the show this morning.
Thank you. How are you?
I'm doing well. I hope you're doing well too.
Fine.
Great. So for some people, we saw the processes triggered earlier in the administration of Nana Dankwa Akufo-Addo. It did not see the light of day. He says those petitions lacked merit. Now petitions have been presented again. We are told that at least 3 have been presented to the president, for which reason he's forwarded them to the Council of State for advice, among others. Your initial thoughts on the petitions to remove the CJ?
My initial thoughts are simply that Nana Akufo-Addo, when he said what he said, appeared to me the authority to have said those things. I mean, the removal of Chief Justice is regulated by Article 146, 6 to 11. And when you see the president has...
Hello, Alaj. Your line is a bit unstable. If you could just reposition so that we can get you clearly, I guess that would really help the conversation.
So, yeah, can you hear me now?
Yes, I can.
So I'm saying that, well, Fado to say that the petitions, because it appears to me on Article 146 and particularly Article 1466, that Nana Akufo-Addo, when he said what he said, did not have authority to make a conclusive determination on the merit or lack of merit of a petition to remove Chief Justice. But the president has acted in provisions of the Constitution or pursuant to the provisions of the Constitution, and that's Council of State. You see that the referrer is very terse. It didn't see it's just that he's referring to the Council of State for. And so when the Council of State receives the petition, set up a committee. If that there's merit in the petition, to set up a committee.
Right. Alaji, I think we'd have to call you back because the line is really not helping the conversation. So we'll call you back and then we can have that conversation. That's the former Member of Parliament for Tamale Central, Alaji Yunusa Fusheni. He's also a legal brain, and so we would want to get his thoughts. But preliminarily, he's talking about the fact that, well, what the former president did, there was some challenge there. We'll get to understand whether or not presidents do have discretionary powers when it comes to determining whether a case or a petition has merit or not. You can get interactive with us on social, on Facebook, on YouTube, and on X at Starr 103.5 FM. But let's try again and see if we have a clearer connection now. Hello, Alaji.
Yes.
Fantastic. So it's a lot better now.
Okay.
Yes, but earlier you were commenting on the actions of the former president. Is it the case that presidents do not have that discretionary power to determine whether or not a case has merit?
On close reading of the Constitution, the president doesn't seem to have those discretionary powers.
Right. So the president cannot, on his own, determine whether or not that petition has merit.
No, he cannot. He's not clothed with that authority.
Interesting. So what's the process, basically, for petitions that are received for the removal of a Chief Justice?
Well, so for example, upon receipt of a petition to remove a Chief Justice, forwards the petition to the state, and if the Council of State, and that place, the Council of State is not, we need to look at that carefully. The Council of State decides that the petition has merit, it will president to set up a committee of a certain number to look at the petition. The advice will be coupled with an advice to suspend the Chief Justice and then start its work. So if the petition and things that the Chief Justice the president will and be removed, the president will have to act with the recommendation committee. They come to the conclusion that no, the Chief Justice cannot be removed on the basis of the petition sent. The president will also have to act on the basis of the recommendation. And then where the chief is subject to by the committee 1466, on the advice of the Council of State, will have to suspend SS. And any time after suspension of the Chief Justice. I believe that if you read it together with Article 146, where the Chief Justice is of the him or her ID petition, the President, Article 1611, means the suspension of the or released the Chief Justice from the suspension of the under Article 101.10.
So, for the purposes of clarity, the suspension of the Chief Justice would kick in when the Council of State makes the determination that, well, there's something, or the committee makes that recommendation that, well, there's something that needs to be looked at here.
Yes. On the advice of the Council of State. So,
on the advice of the Council of State.
So the petition will does two things: to set up. Council of State believes that there's the basis for setting up a committee and provision of 466 to suspend the Chief Justice.
Right. So, as it stands now, we're told from the communication from the presidency that, yes, there's that consultation with the Council of State, because the president has forwarded the 3 petitions to the Council of State to commence consultation processes mandated by Article 146 of the 1992 Constitution. So, when the committee is set up and the determination is made, suspension follows. What follows after that?
So, the committee will do its work, recommend either the removal or the Chief Justice what they have found. And the President has discretion again in that matter. He has to act in accordance with the recommendation of the committee.
So then clearly there's no discretion whatsoever for the President in the process.
It could not be, because the President is the head of one arm of government. The Chief Justice is the head of another arm of government. So if the President has a discretion, the rules of separation of powers.
Interesting. And then what do you make of the conversations around the fact that, well, we seem to have this happen and for other states or other organs, when governments change, clearly then there's the expectation that these others who were also appointed by a certain administration need to change?
Well, it doesn't run. I don't think that we should be encouraging that for people to think that when changes, the people must change. But actually, it's on those offices. You see a petition being brought up is an occupant from office for his office removal, a particularly constitutional office. Jan stayed in office. Did we read in the papers that a petition has been brought to remove him? It actually depends on the nature, on the character and the performance. If the occupant of the office give people the perception that that person has, his group of people, or is not competent enough, that's what happens. And so, yes, one responsibility is on the office to try to demonstrate neutrality and impartiality in the way the person performs his duties in that office. And second, the appointing authority has to ensure that only people demonstrate that neutrality and impartiality occupy those offices, and then have this clamoring for the removal of a Chief Justice or any of the occupants of a constitutional office. It comes down to those people, neutrality, and
So basically, it hinges on petitions that are brought before the presidency, and not necessarily because there has been a change in government. Automatically, there needs to be a change in leadership for these various agencies as well.
Well, so the Council of State, clearly, the term of office of the Council of State, as provided by the Constitution, is contemporaneous to the term. So it gives no one out that when the Council of State list. So you can do nothing about that.
Right. All right. Well, Council, thank you. Thank you so much for the education this morning. We appreciate your time.
Okay, thank you.
So that's a former member of parliament for Tamale Central. He's also a private legal practitioner. Yeah, he says the president has no discretion whatsoever when it comes to the appointments or when it comes to changing the CJ.